Hello, everybody.
State of North Dakota versus Amber Dawn McIntyre, file 47-2025 CR9. Mr. Gonzalez appears on behalf of the state. Ms. McIntyre appears personally without counsel. Sir, were you present in court when your rights were read to you earlier?
Yes, sir.
I apologize, ma'am.
Yes, sir.
All right. One of the important rights you have is the right to be represented by counsel at every stage of the proceedings. You have the right to hire a lawyer or apply for a public defender or represent yourself. It looks like you already applied for a public defender, and based on your income, the clerk's office denied your application because you're substantially over the public defense income thresholds. So how would you like to proceed with respect to your right to counsel today?
Represent myself.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to counsel?
No, sir.
All right, ma'am. And just so you understand, if your financial circumstances change, or if you are categorically unable to retain a lawyer if you want one, you can always reapply for court-appointed counsel. But typically, if your income is above the financial guidelines, you would need to demonstrate the efforts you made trying to secure counsel by saying, I contacted these 7 lawyers and their retainers are X $1,000, Y $1,000, Z $1,000, and the like, and I just can't do that. Usually it requires you to submit a monthly budget demonstrating your financial need in an affidavit form, and then the court can reconsider and override the guidelines. But that's something that's not done very easily, and you have to provide some documentation before the court would consider that. Understand that, ma'am?
Yes, sir.
Right. Have you received a copy of the charging document in this case?
Yes, sir.
Is your name and date of birth correct on that document?
Yes.
You have the right to have that document read to you in its entirety, or I can summarize it for you. Are you okay with the court summarizing it?
Yes.
All right. So the state alleges that on or about December 12, 2024 in Stutsman County that you committed the criminal offense of violating a disorderly conduct restraining order by having physical contact with or coming within 50 feet of an individual with the initials CL, and that you knew a disorderly conduct restraining order had been issued on November 6, 2024, and that you were served with a copy of that disorderly conduct restraining order on December 13, 2024. So you were in court when the court issued the disorderly conduct restraining order, and then you were later served on December 13 with a copy of the order protecting CL. Do you understand that?
Yep.
Mr. Gonzalez, I want to make sure I understand. Is this an allegation of a violation of the temporary order or the permanent order?
I believed it was the temporary order initially. I would have to check the records a little bit more, a little deeper, but I do believe that it was just the temporary order at first.
Well, I think that your complaint, you might need to do a bill of particulars or allege specifically, because ordinarily when a temporary order is issued, that remains in effect until the permanent order is served. So just, I want you to be really clear about what order you're alleging has been violated, whether it be the temporary or permanent, on December 12th, because if it's the temporary order and that was not served until December 13, this may not be a violation. If it
Your
was the
Honor,
permanent,
apologies for interrupting. This is the actual disorderly conduct restraining order, the permanent order. I do have it here in the file itself. It seemed to be, this was the one that was on the 6th of November, 2024. So this was the permanent, not a temporary one.
all right. And so was there a temporary order in place until December 13, 2024? Usually those orders are issued on an ex parte basis until the permanent hearing. And that's why I'm trying to make sure I understand.
I understand, Your Honor. I'm just going through the order in itself. What I have here is that it was heard by the court on the 6th of November of last year. There was findings made on the record. I'm looking at the important notices and that that the order would remain in full force until June 1st of 2025.
All right, thank
Again,
you. And so, ma'am, as charged, that is a Class A misdemeanor. It carries with it the maximum possible penalty of 360 days in jail, a fine of up to $3,000 or both. There are no applicable minimum mandatory penalties. However, if you're convicted of that offense, the court is required to impose certain court fees. In your case, those court fees total $360. If your conduct caused any loss or financial harm to another person, the court's required to order restitution, which is a financial award to make that person whole financially. If you're not a United States citizen, this offense can carry with it adverse immigration consequences. There may be other collateral consequences the court has not explained to you. Nevertheless, those are real consequences. Do you understand the nature of the charges and penalties as I've read them?
Yes, sir.
All right. And so in misdemeanor level cases, the court is going to take a plea of either guilty or not guilty today. If you plead not guilty, the court will schedule further proceedings and set your bail. If you plead guilty, there won't be any trial of any kind. You'd be waiving those rights that were read to you earlier, and you likely would be sentenced today. Do you understand what happens if you enter a plea of not guilty or guilty?
Yes, sir.
To this charge, violation of a disorderly conduct restraining order, Class A misdemeanor, how do you plead, guilty or not guilty?
Guilty.
Before you do that, Mr. Gonzalez, what would you recommend to the court if Ms. McIntyre were to plead guilty?
were she to remain with her guilty plea, I would just be recommending a 360 days. If there was any, have you served any jail sentence at all? No. Then it would just be 360 days suspended for 360 days of unsupervised probation, a distance provision of the 50 feet, the no contact with the individual with the initial CL, and the mandatory court costs and fines. I'm not looking to put the Miss McIntyre into jail, not looking for supervised probation, really here to ensure that the no contact is being met and having a 360-day sentence with the 360 days of unsupervised probation. I believe that meets my qualifications and achieves the goal that I'm trying to reach here today.
All right. And are you offering that as a plea agreement that's binding on the court or as a sentencing recommendation to the court?
I would hope that it would be binding if you're in agreement, ma'am.
That's fine.
All right. So, Mr. Gonzalez, you're presenting that as a Rule 11C1C binding plea agreement?
This is correct, Your Honor.
All right. And ma'am, what that means for you is I have two options. Well, three options really, but in your case, two options. I can either accept the plea agreement as it's been presented and sentence you accordingly, or I can reject the plea agreement and tell you I'm going to sentence you more harshly, or I could sentence you more harshly than what the state is recommending. It could be more favorable to you as well. You won't know that at the time, but you, in a binding plea, if I do something different, if I reject it, you would have the absolute right to withdraw your guilty plea and have a trial if you want. If I accept it, I would be bound to follow the recommendation or the joint plea agreement and include that in the court's judgment. I wouldn't be allowed to deviate from the plea agreement, and if I did, you'd have the absolute right to withdraw your guilty plea. When you listen to that rights video, Judge McCullough explained to you the process that happens when a person offers a sentencing recommendation, which is not binding on the court. In that circumstance, when it's a sentencing recommendation, even if it's a joint sentencing recommendation, the court is free to impose whatever sentence it feels is appropriate. And then you would not have the right to withdraw your guilty plea unless you established that it was a manifest injustice not to do so. Do you understand the difference between a binding and non-binding plea agreement?
Yes, sir.
And are you intending to move forward here on a binding plea agreement?
Yes.
And so you understand that even if I thought it was too harsh, I couldn't change it. I would have to sentence you according to the bargain you struck with the state.
No, I don't want it.
So I just want to make sure I understand. You don't want that binding plea agreement? Or you want to argue for something different? You want me to, what do you want me to do here?
Apologies, Your Honor. I seem to have some kind of situation where somebody in the gallery is speaking to the defendant, offering advice on how to plead, and why to plead, and I'm just kind of having a little bit of issue and concern with this. So I'm just wanting
Thank
to
you.
bring it to the
So-
court's attention.
Thank you, Mr. Gonzalez. So I want to be really clear. Anyone in the gallery needs to be absolutely silent. They cannot give the defendant advice unless they are an attorney and they are representing the defendant. So if that person speaks again, I did not hear what was said. The microphone did not pick it up, but if Mr. Gonzalez hears someone in the gallery offering the defendant advice, Mr. Gonzalez, let me know, and I will direct the court security officer to escort that person out of the courtroom. Are we
Understood, Your
clear?
Honor.
All right. So we're going to start this over. Ms. McIntyre, do you
So
understand that
is
you
the
have?
binding one agreeing to what the state's attorney had said then?
So if you offer a binding plea agreement, what you are saying is, Judge, this is the deal. Sentence me according to the deal. If you don't sentence me according to the deal, then you would have the right to withdraw your guilty plea and have a trial. I would be stuck even if I thought the sentence was not what I would ordinarily do if it was just up to me. I'd be stuck. I couldn't go more lenient and I couldn't go more harsh. I would have to impose the sentence that was agreed upon and presented to me as a binding plea agreement. Okay, and so I'm telling you that I can't give you advice on what to do other than say, here's your choices. If it's presented to me as a binding plea agreement, I must follow the agreement or I must reject the agreement. If I reject the agreement, you can still move forward, but then it becomes a non-binding sentencing recommendation. That means the state's attorney gives me a recommendation, and Mr. Gonzalez has done so, and you can argue for whatever you want to argue for, and I would be free to impose whatever sentence I thought was appropriate. That could be more harsh than what Mr. Gonzalez recommended. It could be more lenient than what Mr. Gonzalez recommended. I can't tell you in advance how I would sentence you because I haven't heard what I need to hear in order to make that decision yet. But that's the difference between a binding and a non-binding plea. Do you understand?
Kind of.
Okay. So are you intending on offering a guilty plea pursuant to a binding plea agreement or not?
I want to go with what the state's attorney said. So whatever one that is.
So you're offering that as a binding plea agreement, correct?
Okay. Yeah.
All right. Do you understand, ma'am, that you have the right to plead guilty and you have the right to plead not guilty? And by pleading guilty, you're waiving the right to a trial of any kind to a judge or a jury. In this case, the default number of jurors is 6. You could demand a jury of 12. All of the potential jurors would have to unanimously find you guilty before you could be found guilty. I said potential and I didn't mean potential. all of the trial jurors, whether that is a jury of 6 or a jury of 12, would be required to unanimously find you guilty before you can be found guilty. You're waiving the presumption of innocence. You're waiving the requirement that the state prove you guilty beyond a reasonable doubt. You're waiving the right to confront and cross-examine witnesses against you, the right to remain silent and to testify for yourself. You're waiving the right to present witnesses and evidence on your own behalf. You're waiving the right to require or to use the court's subpoena power to require witnesses to appear. You're waiving all defenses that you perhaps could have had. You're waiving any and all non-jurisdictional defects in the case if there are any, and you're limiting your ability to appeal the case. You understand all of the rights that you're waiving if you decide to plead guilty.
Yes, sir.
And do you still want to plead guilty?
Yes, sir.
Has anyone made any threats to you, coerced you, or made any promises to you other than what was just disclosed as a binding plea agreement in
No,
order to get you to plead guilty?
No, sir.
No one has told you that you have to plead guilty, right?
No, sir.
Is this what you freely, knowingly, and voluntarily want to do?
Yes, sir.
You've been given an adequate opportunity to discuss your rights, any potential defenses, plea or plea agreement, and potential for sentencing with an attorney.
Yes, sir.
And I understand that you aren't represented by an attorney right now. Do you need more time to think about it before you make a decision?
No, sir.
And Mr. Gonzalez has presented a binding plea agreement. Is your plea of guilty the result of that discussion, and you intend on offering that as a binding plea agreement?
Yes, sir.
All right. So we're going to do this again. You're charged with 1 count of violation of a disorderly conduct restraining order, a Class A misdemeanor to that count. How do you plead? Guilty or not guilty?
Guilty.
Mr. Gonzalez, a brief factual basis.
Briefly, Your Honor, as outlined on the declaration of probable cause in the investigation report, the incident date, December 13th of last year, Sheriff's Office took a report of a DCRO violation. The complainant was the mother of the protected party. Stated that they were at a school concert and that the defendant was within 50 feet of the protected party at the time.
Pam, is that essentially what happened?
Yes, by mistake.
Tell me what you mean by that.
So I was sitting in the front row at the Christmas concert watching my daughter. And when she was done, I continued sitting in the front row. And I was preoccupied with my husband and I's friend. They have a baby. And I was preoccupied playing with the baby rather than what was pretty much in front of me, which I guess was where the violation came in. When like I said, I didn't realize she was right there. And if I would have realized that, I would have moved, because it's not like I'm going to purposely go out and cause this kind of more trouble for me.
Mr. Gonzalez, do you still believe a sufficient factual basis exists?
I can continue reading the investigation report if that clears any confusion for the court. So going back to the Christmas concert on December 12th, 2024, the mother had reported that Amber McIntyre, who was the respondent on the order, was within 50 feet of the order, stated that Amber was seated in the front row of the gymnasium and the bleachers were set up within 50 feet where Amber was seated. CL was on the bleachers during the Christmas concert and was described by wearing a jean jacket. Miss Boom, principal at the Montpelier School, informed me being the officer in question, that Amber McIntyre was seated in the front row and was within the 50 feet of CL. Amber was described to be wearing a gray hooded sweatshirt. The sweatshirt also said McIntyre at the back of it, which can be seen in the video footage. The officer obtained the video footage from the Montpelier School of the incident. Mrs. Boom, the principal, informed the officers that the grade concert began at 18:30 hours and CL was in the 7th grade portion of the concert and has been on the bleachers between 1750 to 2000 hours. Officer spoke with Amber McIntyre about the incident via phone, which was recorded. She stated she didn't pay attention, that CL was in the concert, was informed that she was well within the 50 feet, continued to say that she did not realize it. She was informed of the document for the incident, informed that she had kids there, and was informed by the staff at the school that she was well within the 50 feet. So that is what I have as the investigation report that was submitted to the affidavit of probable cause. I can go into I believe that there is an even incident number report that does state pretty much the same thing. Roughly that she was within the 50 feet of the restraining order and knew that she had a restraining order out on place of her with the protected party CL.
All right. Here's what I'm going to do. At this point, I'm going to reject the plea agreement and not receive the defendant's guilty plea at this initial appearance. I think there's some concerns and inadequacy concerning the willfulness of violation. The offense is not a strict liability offense. There still must be a knowing and voluntary violation or a willful violation of the court's order. I was the judge that imposed the disorderly conduct restraining order. I recall on the record having discussions with the defendant and the parties, which is why it contained a 50-foot restriction instead of a 300-foot restriction, which is the default in those types of proceedings. I'm just going to reject everything at this point and enter a not guilty plea on the defendant's behalf. So I set bail and set further proceedings down the road. Mr. Gonzalez, thoughts on bail?
I was just going through the file in itself and looking to see if there was any clarification to the willful portion that the court is highlighting. And given the fact that the only thing I have is the affidavit of probable cause and as well as the investigative report that doesn't really highlight the willful portion other than reiterating that the defendant did not know, I'm just going to move to dismiss this case, Your Honor.
Case dismissed. Mr. Gonzalez, can you prepare just a one-sentence order for the reasons stated on the record? Case is dismissed.
I can do that, Your Honor, yes.
Thank you. So, matter is dismissed, ma'am.
What's that mean?
That means that this is not going to be on your record. It'll show up as a charge, but it'll show up that it's been dismissed. I'm going to sign an order of dismissal. Mr. Gonzalez has moved not to prosecute the case, and I approve that motion, and I'll sign off on the proposed order when he prepares and submits it.
Okay. Well, thank you.
Ms. McIntyre, just so you understand, you need to be aware of those things. I know that both your daughter and the protected person go to the same school. The reason the court set that 50-foot perimeter was to allow you to attend proceedings involving your daughter, but you just need to be more cognizant and aware of where CL is and stay away from her and not have contact. So here, essentially, it appears as though it might be an accidental contact. You just need to be more aware of that in the future because you are restricted in a way that other parents are not. Do you understand?
Yes, sir.
Do you have any other questions?
I do not.
All right. That matter is adjourned. Thank you.
Thank you.
Be safe, be well, sleep sweet, and much love.